bound to say we hadn't anticipated such a high level of public interest in this rating appeal. Is there actually enough room in the courtroom for all the people who have to be here? If there isn't, we can look into using a larger courtroom tomorrow.
It is surprising, but it's consistent with past experience. These cases are actually...
Yes. Well, we can make inquiries.
Perhaps it's the star quality of the counsel's hearing.
Well, they've arrived a bit early for the start. I'm nearly at the end of Southern Railway. I think I do, however, need just to touch on two more points, please, if you will indulge me from Lord Wright's speech. I was distracted from page 560, where Lord Wright explains why, in principle, he says these individual units ought to be separately rated. There's reference to Electric Telegraph Company and Overseers of Salford. I'm now taking it... I'm sorry, I'm on page 1335.
Yeah.
There was sufficient permanence to constitute rateability. That principle applies, in my opinion, to the bookstalls. They and the sites on which they stand are in fact beneficially occupied. Like any of the other shops or premises in the station, it would be unfair that they should escape being rated while the other premises are rated. I know I keep repeating the point, but it is so foundational. We have to look at the smallest unit, not for some arbitrary reason, not because there's a range of alternatives which is equally available from which the court may select, but because one is driven always to look at the smallest unit of accommodation, of occupation, in order to ensure fairness between all ratepayers. And Lord Wright reverts to this point right at the end of his speech on page 565. I say right at the end of his speech, he still has to deal with the showcases, but we've seen how he dealt with those. At the bottom of page 565, in all the circumstances of the case, I think this House is entitled, and indeed bound, to refuse to affirm the peculiar anomaly which would exist if W.H. Smith & Sons bookstalls were treated differently from the other shops and offices at Victoria. Although it is counterintuitive, I appreciate that, the decision of the Court of Appeal in our case is anomalous. It is the anomaly. The next case I need to show the Court, if I may please, is LCC and Wilkins. This is in tab 14 of volume 1, memory stick 1154. This was the case about whether builders' huts were to be treated as in the separate rateable occupation of the builders who were on site doing the building work. And they were. The judges use different forms of words. The pithiest, and I'm doing what I can to save time, the pithiest is perhaps the speech of Lord Oaksey, starting at memory stick 1167. Towards the foot of the page, a consideration of the authorities leads me to the conclusion that an occupier who makes any beneficial use of land is rateable if he does so for a period which is not transient. The contractors undoubtedly occupied the land on which their huts were placed and got benefit from it, and the fact that they didn't pay any specific sum for the occupation is irrelevant. There's then reference to Salford. Can I take it up from halfway down the page? I'm therefore in agreement with Lord Justice Jenkins that the case of Holland and Hodgson is really relevant, since the present question is not whether the huts form part of the realty by reason of the way in which they were annexed to the land and the intention with which they were so annexed, but whether the contractors had sufficient possession of the huts that they could maintain trespass in respect of them and derive a benefit from their use for a period which has been found not to be transient. It's making the point that it doesn't matter that the occupation was by a chattel. You don't get involved in the question whether it was a fixture or part of the land or not. It was the use of that chattel for a beneficial purpose which triggered rateability. Lord Radcliffe gave the most fully reasoned speech. I'm going, to invite the court again, to trespass on the court's time, perhaps outside this hearing, to read the whole of this speech. It does repay careful reading. I'm doing what I can to fill it down the points. If one can look at page 878, at the top of the page, memory stick 1170. I should take this up from the bottom of the preceding page. My lords, I don't think that all the curious and complicated learning which can be brought to bear on the question whether a chattel is in law part of the freehold when the property rights of contending parties have to be resolved is of any direct assistance when what is in issue is the rateability of a structure by which it is claimed that a person occupying it occupies the land which is its site. This is exactly on point. For such a purpose, we must look to a less meticulous standard of inquiry. No one supposes that a man is rateable in respect of the enjoyment of chattels, as he is in respect of the occupation of land. But on the other hand, I think that that's a long way from saying that the presence of chattels on land can never be a relevant factor, either in determining the assessment of the rateable value of a hereditament or in determining whether there's a rateable occupation or not. He gives the example of Kirby and Hunslet. Then he turns to what he had called the second point. And the second point, if you want to identify those, is at the top of page 1169. That's where he tells us what the second point. It is permanence. Was the occupation sufficiently permanent? So that's what he's talking about from halfway down page 1170. On the second point, I think it's equally well established that a structure placed on another's land can with it form a rateable hereditament, even though the structure remains in law chattel, and as such the property of the person who placed it there. Reference to other chattels. If one can then go over to the next page, 1171, just above the halfway point, quoting from Lord Justice James, there's no dispute as to the general principle of law, viz. That where any part of the soil is permanently occupied by anybody for profitable purposes, as for instance when it's occupied by a company by means of its water or gas pipes or telegraph posts, then the person so occupying is rateable in respect of such occupation. And then he comes to Southern Railway, which I've just looked at it. He says Southern Railway is only a natural application of the law of rating formed in this way. Absolutely my point. It's all we're talking about is an outworking of the fundamental proposition that rating captures as liable people who occupy land and everyone who occupies it, satisfying the land criteria. Taking it up from the bottom of this page, 1171, in the result it was held that they were so capable, that is capable of being separate assessments, since they were in separate occupation, and the occupation itself possessed a sufficient degree of permanence. Then he deals in the next paragraph with an argument which I don't think is pursued, and so I think we can skip over that. But then halfway down page 1172, in my opinion, the present case really centres round the question whether the sheds erected on a building site by a building contractor for the purpose of his operations involve such a degree of permanency in his occupation as to make it a rateable one. I've no doubt that in considering this, it is at any rate relevant to ascertain to what extent and in what way these constructions have been made a fixed part of the site on which they stand. For the more casually they're attached, the less likely it is that the occupation of them will be found to be a permanent one. In this sense, it may be of some importance to inquire whether they are chattels or not. But to make the whole issue of rateability depend on the bare issue, for instance, whether a particular structure has or has not foundations in the ground, which give it a measure of lateral as well as subjacent support, would be to use a legal distinction for a purpose for which it was never intended.
Can I ask you in relation to the previous paragraph?
Yes.
About halfway down it, the line 8, I think, Lord Radcliffe says, well, when the owners of pipes, cables, posts, etc., are rated as occupiers, they're rated in respect of those things themselves, by means of which they occupy land, not merely in respect of the land that is occupied. Now, and he gives the example of Corey and Bristow. Now, what if the things themselves are not rateable?
Well, the huts themselves weren't rateable in London County Council and Wilkins. They're non-rateable chattels also. The bookcases, the goods display cases in Southern Railway weren't rateable as chattels. They were equally non-rateable chattels. He's not making that point. The point he's making is that there is value through the occupation of these items. And it's through that occupation one identifies a beneficial occupation of the land on which they're situated.
I see. So when he says they're rated in respect of those things themselves, that I must unpack that.
You do.
So the concept of a rateable chattel, I'm not sure I understand that.
No, the rateable chattel is the one which has become a fixture and is listed as one of the items in the plant and machinery regulations.
Do the regulations use the word chattel?
No, I don't think they anywhere use that word, but they are describing things which lose their chattel.
Sorry, I thought you were using a technical term.
No.
Now, I understand on the plant and machinery regulations there's a whole self-contained code of how you deal with things defined as plant and machinery.
Exactly.
But here, we know that these ATM machines are not taken into account for the purpose of valuation.
Exactly.
But you say that doesn't mean you can't take them into account for the purpose of deciding if there's a hereditament.
Yes, and whether there's occupation or not.
That's a question I have at the back of my mind, and no doubt others will help me on.
That's exactly right, and that's the point that Lord Radcliffe is making in that paragraph. That I'm sorry, I didn't mean to skip it over. I
wasn't suggesting you were skipping over the difficult part.
No. So I think I've now shown you what I need to show you from that page, but there's a very important passage, if I may, the top of 1173. Again, I'm sorry, you have to take it up from the bottom of the preceding page. That being said, I see no reason why any particular part of the site, if sufficiently defined by the fact of its appropriation for the support of a building or structure, should not itself thereby become rateable. Reference to Lang. In that case, the building owner himself specified the site to be reserved for contractors' buildings. Here it was left to the contractor himself to appropriate what and as he required. But I see no importance in this distinction, given that a defined site is appropriated and used as the floor of a building. This meets a number of the questions that I've been dealing with from the bench about what is, if you like, sufficient evidence to demonstrate the existence of a hereditament. Do you need anything more than the fact of occupation itself? Answer, no, explicitly stated. Certainly, continues Lord Radcliffe, it is true that the law demands that an occupation to be rateable should be permanent, but then it is equally certain that permanence does not connote what it might appear to in this connection. It is rather easier to say what it does not mean than what it does. Occupation is not the less permanent because it is that of a lessee who holds under lease for a fixed term. In other words, there is permanent occupation, however clearly the end may be in sight. More than that, an occupation can be permanent even though the structure or other chattel which is the means of occupation is removable on notice. That's Lord Carr's point. It's not necessary to go as far as Lord Campbell, the Chief Justice, who suggested that some pipes were liable to be recited by paving commissioners as occasion required rateable because they had a movable freehold. It may be that permanent signifies no more than continuous as opposed to intermittent physical possession of the soil, as is suggested by Ryde. However that may be, it is well settled that a tenant at will has an occupation that's sufficiently permanent to carry rateability. If that is so, I see no reason why the contractor's occupation of his huts during the pendency of the building contract shouldn't produce a similar result. Finally, there's just an interesting point that Lord Radcliffe touches on as to, if you like, part of the rationale for that. It's over the page 1174. The question whether there is sufficient permanency of occupation is essentially a question of degree, and as such is a proper question for the final determination of the Lands Tribunal. If the evidence had been, as it was not, that the huts or sheds were constantly being moved from one site to another, so that there was no real appropriation of any particular area of soil for the purposes of occupation, of course I'm mentally underlining those words, I can see that it might be necessary to say that the law did not admit so transient an occupation to be a rateable one. But all that we know is that one structure was once moved during the course of the operations, and I do not think we ought to assume that the occupation was in fact more transient than the evidence suggests. If so, 18 months on the site does not present itself to me as something inherently too brief for rateability. The rate is an annual impost on the occupier in respect of his profitable occupation of land. It's not a capital charge on the owner in respect of the property interest in the soil. If such an occupation in fact endures for a year or more, I do not see why the occupier should not contribute to the current fund of the rating area for that period. The mere brevity of his occupation will be itself the cure of any hardship in his liability. That, again, is reasoning that is rooted absolutely in fundamental principle. Lord Tucker's speech starts on this page also. He speaks really to the same effect as Lord Ratcliffe.
Was there any argument that the builders were in fact doing what they did for the purposes of the owner of the site? So there was a sort of synergy that we arguably have here. It's unlike the Southern Railway case there in the sense that there were distinct purposes, but here the whole purpose of the buildings was for the purpose of the school.
I'm trying to remember.
Doesn't seem to come up, I don't think.
Does or doesn't. I'll have to check that. But I call attention in Lord Tucker's speech at page 1171.
And it may be a point in your favour if it wasn't suggested that that made any difference.
Yes, I'm not dodging the question. I just can't, on my feet, remember, with all the other stuff in my head, what the arguments were in this case. I'd have to go back, and I'm in no better position to answer it than anyone else with a copy of the case in front of him at the moment. But at page 1176, there's reference to Corrie and Bristow, the facts of which are very briefly stated. All this reasoning is part of the same theme. But I call attention to the paragraph beginning. I do not think the fact that no particular area was defined by the contract as the site for the huts is decisive in favour of the appellants. If in fact the contractors had the right to select the sites and did in fact select and exclusively occupy certain sites with the licence of the building owners for a sufficient length of time, I find difficulty in distinguishing the consequences in each case. In my view, on the undisputed fact, it's impossible to hold as a matter of law that there was no evidence to warrant the finding that there was in this case a sufficient carving out or appropriation and sufficient degree of permanence to give rise to irratability unless the appellants can make good their submission that these huts, by virtue of their construction and liability to removal, were to be regarded as mere chattels which cannot be the subject of rating or even taken into account as enhancing the value of the occupation of an otherwise rateable piece of land. And of course the upshot is they couldn't make good that argument. Mr. Kalinsky relies on this passage in a way, in his case, in paragraph 30, in a way that I struggle to understand, but no doubt hear from him further on that.
Is it a bit different, this, from our case? Because, at least in those days, the building site wasn't rateable, and so the only candidate was the huts.
That's true, and that's a point that Lord Tucker refers to on page 3, I think it's page 385, if my note says. Yes, 1177. Furthermore, a decision in favour of the appellants would, in my view, be contrary to the basic reasoning of the speeches of this House in Westminster. It is true, as pointed out by counsel for the appellants in the present case, that in that case the whole area of Victoria Station was in any event rateable. I think this is my lady's point.
It is.
And the only question was whether certain persons other than the company should be separately rated in respect of certain portions, or whether the whole was a railway hereditament. Nonetheless, in order to be separately rated, the portions in question had to come within the divisor which we looked at.
But it's a different context from our context in the present case, where there are two potential occupiers.
Yes, but the point being made by Lord Tucker is that that's not a point that makes a difference. This house, he says in the next paragraph, this house held that various structures, some of which were easily removable, and were in the nature of chattels, were so let out as to be capable of separate...
Well, that tells you that they're capable of being in occupier A's occupation, but it doesn't tell you whether that's the person who is occupying those places.
I respectfully suggest that when one takes this passage in its context, he is saying there is no material difference. He's saying that is not a point that makes a difference to the analysis. Mm. He's expressing himself in this way because of the recognition in the House of Lords that there was a question of judgment to be applied by the fact-finding tribunal. That's the only reason he's expressed himself in that way. He's not saying that in law there is a distinction between the two cases. The reverse is the case. He's saying in law the situations are the same. I think you can get that from the rest of the paragraph I started to read. Having regard to the counsel engaged in the case and the elaborate speeches of their lordships, it would be remarkable if it had escaped the notice of all concerned. The short answer to the case was that the chattel character of the structures of itself alone rendered them capable of being let out so as to be capable of separate assessment. I respectfully repeat that is an answer to my lady's question. Because they're recognising that Southern Railway is on all fours with this point. Movability is no more or less relevant in one kind of case than the other. So that is Wilkins. The last of the great leading cases is Mazars, that I need to show you. This starts behind tab 23 in volume 1 of the Authorities Bundle. Memory stick 1359. I summarise very briefly what this case was about, though it's familiar, I'm sure, in general terms. It was the case about the firm of accountants who had an office in a building. But the problem for them is that the office they had was split between floors. They had, I think, the first floor and the sixth floor. One of the points being made was that from the perspective of the office owner, from the perspective of the accountants, economically, so to speak, that's no different from having one office on the same floor. And as I said, one can sympathise with that view from an economic standpoint, from the perspective of the office occupier, that's intelligible. But that wasn't the right perspective in Mazars, and it's not the right perspective in our context either. And the reasons for this are given in the leading judgment of Lord Sumption, which starts at page 1363, with whom Lord Carnwath and Lord Toulson agree. I commend the description of rates in paragraph 1, because, again, Lord Sumption roots himself absolutely in the most fundamental characteristic of rates.
I mean, this is a very different case, because the whole question here was whether it mattered that they were physically separate. And that's not a point we have in this case.
Oh, that is true. I accept that. I'm interested in the reason. And I'm going to suggest that it is illuminating to see the reasons of the Supreme Court.
Well, I was party to this, so I'm intrigued to know how it helps us in the present case. No doubt you'll tell us.
Well, for example, in paragraph 5, the question which arises in a case like this is a very simple one. Given that non-domestic rates are a tax on individual properties, what is the property? It's the emphasis on...
Well, I mean, we knew that.
Oh, okay, it may be an example of me over-egging things again, in which case I apologise.
Yes, if we hadn't got that from the cases you read so far, we would have been very well.
Let me then confine what I get from Mazars to two narrow points. One is at the bottom of 1369, between letters F and G. The principles he's extracted are also rationally founded on the nature of a tax on individual properties. If the functional test were to be applied in any other than the limited category of cases envisaged in the principles he's just enunciated, a subject, or in English terms a hereditament, would fall to be identified not by reference to the physical characteristics of the property, but by reference to the business needs of a particular occupier and the use which for his own purposes he chose to make of it. And the problem which Lord Sumption identified resulting from admitting that kind of consideration into the law is explained in 1372. Between letters A and D. Both the geographical and the functional principle are an evaluation of the facts by the tribunal of fact. However, the relationship between them is not itself a question of fact, but a question of principle. It refers back to the 3 points he stated. They cannot both operate in parallel unless there is some rational framework of principle for distinguishing their respective spheres. Reference to the English and Scottish cases. And then below C, the answer to the question must surely be applied by the Tribunal of Law which posed it to treat the relationship between these two incommensurate tests as no more than a question of fact and degree, is to leave to the Tribunal of Fact what amounts to a discretion to give the functional test such weight as they choose against the geographical one, and to allow the business choices of the occupier to determine the bounds of the hereditament. This would in turn make the basis of assessment more opaque and less consistent as between different occupiers. It would be a poor substitute for clear and principled rules capable of uniform application. Lords and my lady, the approach of the Court of Appeal in our case falls into exactly that problem. It invites the decision maker to try to balance two incommensurate things. First of all, what are the facts demonstrating occupation by, in our case, the bank, on the one hand, against why was the bank let into occupation on the other hand? That why question is a result of the Court of Appeal's inquiry into, is the purpose of the bank in occupying its own exclusive purpose or a shared purpose? It's an invitation to weigh incommensurate things. And that is a real problem. It is the same as conferring a discretion. The other point, the second point I make, I think I can make this without further reference to any passage of the case, is this. I hope it's not too abbreviated. But it's as follows. If the business needs of the occupier cannot define the hereditament, even where one occupier occupies both units, how can they define the hereditament when there's not even the same occupier in each unit, but a separate occupying business in each unit? It's an a fortiori point. I'll put it another way. A shopkeeper might have a legitimate business justification which amounts to a need to provide ATM services as part of his retail offer. That's an even stronger case than ours, where there's no finding that the retailer needed an ATM service. But take the facts more strongly against me. Suppose the shopkeeper showed a business need to provide ATM services as part of the retail offer. Just as a firm of accountants might have a legitimate business need to locate the whole office in one building, even if the only space available means they have to take separated floors. If the business needs of the occupier are irrelevant in the second case, how can they be relevant in the first? I need to refer briefly to something Lord Gill said in Mazars, I think, because he rejected an argument put forward by or on behalf of, in fact it was the amicus who took the arguments, on fairness. I've lost it. Paragraph 40. This is at 1378 in the memory stick. To the three general principles that Lord Sumption has laid down, I would add only the comment that in the application of them, the concept of fairness alluded to in this case by the President of the Tribunal has no place, lest it be said against me that Lord Gill is here saying something unlike what I have been saying. The way in which fairness was being used by the President is in the way I've described the economic position of the shopkeeper. The point being made by the accountants was it's unfair, given that we have a business need which has to be satisfied in offices somewhere, that we should be treated differently just because we can't find a single floor and have to be split over multiple floors. That was the point of unfairness being rejected by Lord Gill. And as a sort of, I'm not sure if it's right to call this as an aside. It's not really an aside, actually. It's quite an important point. We shouldn't forget that before Mazars, the leading case in this field was a decision of the Court of Appeal called Gilbert and Hickenbottom, which had stood for many decades. And problems had taken a long time to gestate before a head of steam problematic enough built up for this court to have to set the record straight and overturn Gilbert and Hickenbottom. It's not, I won't say it's not uncommon, but it's certainly not unprecedented for this court to have from time to time to take stock and put things back on the right track. That ultimately is what we are asking the court to do in this case, of course. The next case I need to refer to is the old Consort decision, which is the first of the Scottish cases before the court, I think the first of relevance before the court, at page 1029 in the memory stick. This is the case about the airport owned and operated by the Minister of Aviation, which had in it a bar, a coffee bar, a cocktail bar, and an export shop. And the question was whether the shops formed part of the airport assessment or needed separate entries. Held, each needed a separate entry. Now, it's true that the physical arrangements were unlike those in the railway station. The coffee bar and the cocktail bar were much more analogous to the bank premises or the chemist's premises in Southern Railway than to the kiosks. There's that point of distinction. But the reasoning is an absolutely straightforward application of a conventional Southern Railway approach. If one looks, for example, at page 1036, Lord Patrick's judgment, having directed himself by reference to Wilkins, one must direct one's attention on the new sites and decide according to their circumstances. In this case, 3 heritable units have been created, each capable of being separately occupied, and so on. Then he turns to paramount occupation, and he simply applies Southern Railway. There's an analysis of the agreement, and the whole point of the analysis is to determine the extent to which the minister's rights are such as to interfere with the business being carried on from each of the units by its individual occupier. For example, at page 1038, by way of contrast, what occupation does the alleged paramount occupier have? He has the right to inspect and the right to effect repair, decoration, maintenance, alteration, but not so as to interfere unreasonably with the company's business. And so on. And then there's reference to another of the arguments which crops up later. This point is not noticed in later decisions. Halfway down the page, the argument for the respondents...
So which page?
1038. The argument for the respondents then took a different form. It was said that this agreement was merely an agreement for the performance of services by a contractor for his employer. And the court sees how Patrick disposed of that. Towards the foot of the page, insofar as these items are said to point to this agreement being an agreement by a contractor to render services to an employer, I think that the sufficient answer is that no servant pays his employer substantial annual sums for the pleasure of serving him. So far as they might be said to indicate such a control by the ministry as to place the ministry in paramount control of the premises, I think they're wholly insufficient to accept that. And he's referring back to the controls that the minister was entitled to exercise, which are summarised in the paragraph I didn't read at the bottom of page 1038, but which are indistinguishable from the rights in the contracts in our case. I mean, nobody's tried to distinguish them. One of my main criticisms, both of the Court of Appeal in our case and also of the other ATM cases which are against me, is that there hasn't been this audit of the contractual provisions under consideration in those particular cases with the contractual provisions which were considered in Old Consort, Southern Railway, for example. That audit hasn't happened at the level of detail you would need in order to be able to say the control in the ATM cases is different from what was in the earlier cases. That exercise is missing because in no case has the required level of detail been brought to bear. That's why I apologise for the agony of going through Southern Railway in detail, but not for doing it. It is necessary. Lord Sawn makes an important observation at page 1041. Halfway down the page, just above the second paragraph. No doubt, he says, no doubt the minister was concerned to see that the services in question were provided at the aerodrome. So that's like the store in our case. Of course, the store is interested in seeing ATM services provided as part of its retail offer. And Lord Sawn says, no doubt the minister was concerned to see that the services in question provided at the aerodrome, but in the present case, the method chosen by him to bring this about was to enter into an agreement with the caterers under which they carried on business on their own account in premises given over to their occupancy. That is the ATM case. And again, in none of the ATM cases has Lord Sawn's reasoning, or any of the reasoning in Old Consort, been referred to in detail. Reference is made to Old Consort impressionistically. Unless you actually go back to the reasoning, you miss a point like that. Lord Sawn's judgment is absolutely antagonistic to the theory put forward by the Court of Appeal in our case. Lord Guest at page 1042 refers to the fact, about halfway down the page, the minister had no power to carry on the business of a shop. That might be said to be analogous to the fact that the shops in our case have no power to carry on ATMs. But Lord Guest said that was immaterial, which is why I'm not founding my argument on the absence of any authority by the stores to operate ATM sites. I don't found my argument on the absence by them of the regulatory license they would need. Lord Guest has said it was irrelevant, and I'm not going to argue against that. But that's Old Consort. I mean, I'm doing it briefly again. I'm not discouraging the court from reading it in its entirety. In fact, I would respectfully urge the court, if it can find the time, to reread the case in its entirety. So, my lords, that, and my lady, that brings me to what I'm calling the ATM cases, by which I mean Stringer, Clydesdale, the Bank of England, and our cases. Before I turn to them, may I indicate, based on what I've already been submitting, what are my 5 overall or general criticisms of the ATM cases? First, they adopt the wrong perspective. They look at the whole issue from the point of view of how the presence of an ATM appears from the point of view of the shopkeeper. rather than from the perspective of other ATM operators with units situated elsewhere. Secondly, they take into account the business needs of the shopkeeper in providing cash as part of its retail offer, as a factor which is relevant to the identification of a hereditament, which is contrary to principle, as explained in Mazars. In fairness, I think it's right to say that this point would not have been brought into focus, hadn't been brought into focus until Mazars. It wasn't really a point available at the time Clydesdale was decided or the Bank of Ireland case was decided. It's really this court's contribution in Mazars which brings that point into focus.
So you look at the...
You don't look at the business needs of the shopkeeper as a relevant factor in deciding whether you're looking at one hereditament or two hereditaments.
We decided, well, you know, I hadn't realised we were making a great contribution in that respect. I thought the point was it was a completely separate bit of unit.
I'm sorry, my lord.
I thought the point of Mazars was it was a completely separate unit. It was on the top floor and the other one was on the bottom floor.
Yes, that's right. But it,
Yes. And
well,
the fact that they served a common need didn't overcome that.
that's right. But I was
I would
interested.
suggest in a different case where you're dealing with one contiguous things that need can't come into it.
Well, that I think is what Mr. Kalinsky would say. He would say that a completely different set of principles is available.
I'm not saying that's right or wrong. I'm just surprised you say that we decided that in Mazars when it wasn't the issue.
I'm not. What I'm saying, I'm not saying more than I've just said when I was looking at Mazars, which is that the principle applied in Mazars is as I've described it, and I'm suggesting that that is a point of general principle which ought to apply in this field as well. It's difficult, I suggest, to see why it shouldn't apply going the other direction. But of course, I've made the point. It's your lordships to decide whether it's right or wrong. I'm not sure how, if it can be irrelevant where you're seeing whether two occupations are one, it is relevant where you're seeing whether one occupation is two, one unit is two. I'm not sure how you would justify that distinction. Thirdly...
Well, I'm just thinking aloud, but I suppose, on any view, the supermarket is a hereditament, and the argument that you're presenting is that the part of it which is allocated and occupied by the machine is a separate hereditament, and the question whether it's a separate hereditament seems to be very closely related to the question of who is in paramount occupancy of that part of the store, and functionality might have a bearing on the court's assessment of who is in paramount occupancy.
Well, that depends on how far beyond the test set out in Southern Railway the court desires to go, because in Southern Railway the question is just about control and interference. It's about how does the occupier of the smaller unit experience his or her occupation of that unit. So you would, I suggest, be going beyond Southern Railway if that's the approach you take. My third criticism is that in none of the cases, the ATM cases, is there any analysis of what Lord Tucker called the basic reasoning in Southern Railway. There's reference to passages from Southern Railway, but there's no analysis of why it is that the House of Lords said, focus on the smallest unit. And so the point is always missed that Lord Russell wasn't selecting from a range of available alternatives. He was driven to the smallest unit by the fact that rates is a tax on all occupiers of land. That point goes unnoticed in all the cash point cases. Fourthly, a point I'm repeating myself, I think there's been no audit in any of the ATM cases of the detailed reasons in Southern Railway, by which I mean no comparison in detail between the contractual provisions and the factual provisions in Southern Railway, or indeed Wilkins, or Old Consort, and the contractual provisions and so on in the other ATM cases.
Can you just backtrack a bit? I'm struggling with the question of the relevance of functionality.
Yes.
Surely you say it's all a question of how the, if you like, sub-occupier experiences his occupation. Is it exclusive enough or not? That's where you say you're looking, isn't it? Well, how can you decide on whether it is unless you know what he's aiming to do there? If he's running a newspaper stall and the station delivers the newspapers he's going to sell to his stall and dumps them on the desk, he's pleased. No, he doesn't consider that an interference. No. If they dump their used newspapers on his desk, not so.
But you can see that in that situation there's an interference with his occupation of the land without needing to know anything about function.
Why? The same newspapers, they've got leftover stock, so they dump them on him because they can't be bothered to take them to the bins.
In that situation, all that happens is the occupier protests and says there is an interference with my use of the land for the selling of newspapers. The example that was explored...
If he's selling newspapers there, then it's not an interference, it's a delivery. So I don't see how you can ignore what he's doing.
But it's probably my fault for not understanding the distinction relationship has in mind. The example that was explored in the Court of Appeal was one which was in a way unfortunate, but because it doesn't have the quality of permanence, but which is a simple example and which may help to touch on an answer to your ladyship's question. The question was, suppose I'm walking along the Strand to go to court. What relevantly is the purpose of me being on the pavement? Is it enough to say I am walking? Or does rating require you to say I'm walking to court? And I say rating, for rating purposes, in the analogous field, the correct answer is I'm walking on the pavement. You don't need to know I'm walking on the pavement to court. Now, it's not a perfect example.
And translating that into the ATM in the supermarket?
In translating that into the ATM in the supermarket, it's enough to know that the bank is in occupation of the ATM for its purpose of operating an ATM. That is the purpose for which there is an occupation of the land. You don't need to know that that purpose brings benefits to someone apart from the person operating it. That's not a necessary part of a description of what is going on the land. It's inessential, and the problem with it is you can never do it without venturing into analysing the characteristics of the person who occupies another piece of land. It goes back to the examples I gave at the beginning of my submissions to the court, when I asked the court to imagine various examples which isolated that depending on whether the shop is functioning or not, or whether it's a data centre, the only thing that's changing is the characteristics of the licensor. How can that affect whether the facts which demonstrate occupation of the ATM by its operation by the bank have changed? They haven't. The relevant facts are identical. I'm sorry if that's a long-winded answer.
No, thank you very much.
But
thank you.
At this hour of the day, it's the best I can do.
Thank you.
My fifth overall criticism is that the effect of the ATM cases, if they're right, is that if Southern Railway came up for decision today, the result would be different if the railway company called evidence saying, actually, it's very important for us that travellers should be able to have newspapers while they're travelling on the trains. And I just ask the court to reflect on whether that is really a sustainable way of interpreting what the House of Lords did in Southern Railway. The first of the ATM cases is one called Stringer. It's at tab 18 in the first volume, memory stick 1222. This was back in the days when different banks liked to operate their own networks of cash machines. And so the Sainsbury's stores, certainly this store, the store in question, had a number of ATMs in a secure room, which was otherwise, I believe, so far as relevant, similar to the one I've shown you a photograph of. The tribunal held that the site of the ATMs and the secure room in which they were situated were in the rateable occupation of the store.
You're going to say this was right or wrong?
It's wrong. The reasoning starts at page 1234, memory stick 1234. The member directed himself by reference, starting off by reference to Hickinbottom, which of course has been overturned in Mazars, then by reference to Holkin, from which you got the same proposition that whether a person is an occupier or not is a question of fact. In fairness, he did note that Lord Wright added a passage in Southern Railway by which is meant that it must be ascertained by considering all the circumstances of the case. Lord Wright was making the point that it's an evaluative question which turns ultimately out to be a question of law based on a correct understanding of the facts. But he then returned to Hickinbottom. In borderline cases where a difficulty arises, it's better to employ a common sense assessment of the features of the case than to seek to have recourse to some standard formula. And then what weight was to be given to the different considerations was for the Lands Tribunal, after hearing the evidence and viewing the premises. That's unsustainable in view of Mazars. The tribunal approached this as if it had essentially a discretion, the discretion which has been deprecated by Lord Sumption. Then the tribunal, starting at the foot of page 1234, set out a number of considerations which led to the conclusion I've described. The first of which is really seems to have been the trigger point for the argument which has now been taken up by the respondents, joint purpose. Nothing to do with control. Literally nothing to do with control. The second point, it said that to draw a clear distinction between the provision of financial services through the machines by the 6 financial institutions to customers and the ready availability of banknotes to be spent in the supermarket is entirely artificial, having regard to the joint purpose. Again, nothing to do with control. Literally nothing. Thirdly, the supply of the mutually beneficial service to customers is in practice a complementary joint venture and has been acknowledged to be from the outset. Still nothing about control. In fact, these are all just different ways of making the same point. The cash machines serve a joint purpose. And my whole argument is, well, so, yes, but so what? It's the wrong perspective. And the fourth, without the day-to-day management oversight, services and control of the machines provided by Sainsbury, the ATMs can bestow no benefit upon the financial institutions. The presence in the secure room becomes merely the storage of inoperative chattels. Now here is reference to control. But where is the analysis which shows that the contracts gave to Sainsbury's any control in the sense used in Southern Railway? There isn't any analysis to show that the contracts were in any respect different, any respect that matters different. In particular, there's nothing to show that although the staff were involved in the machine, their involvement was other than as subcontractors for the banks. The fifth point, having regard to the number of financial institutions involved, in practicality, I mean, you can go through to the bottom of that page. You will find there is no consideration of control in the way that Southern Railway requires one to focus on that issue, looking at the smallest unit of occupation. There is a point I I draw attention to at the foot of this page. For these reasons, on the evidence before me, I find that the secure room and security lobby at the supermarket were at the material date in the rateable occupation of Sainsbury and no other party. Pausing there, that might be right in relation to the lobby, the secure room. That might have been right, but it isn't clear how the member has applied that to each individual ATM site. I don't detect any reasoning separately directed to those potential units. I'm not sure I can go as far as to say he forgot about them. I think that would be unfair. But it isn't clear how the points that have been made can properly be said also to relate to the individual ATM sites. And so perhaps it's not surprising that even in Clydesdale, which is the case I'm very critical of, there's recognition that Stringer is not a very satisfactory authority. Clydesdale is next in the list. This is at tab 44 in the replacement volume. In the memory stick, it starts at page 1814. My lords, my lady, if time permitted, I would have gone through this case line by line, because almost everything that is said in Clydesdale is something I object to, almost every sentence. But I don't think I've got the luxury to do that. I again have to trust the court to reflect on the entirety of the judgment in light of the submissions that have been made. I will give you what I'm going to call a minimalist map. It is absolutely minimalist, and there's a danger that I'm going to miss out important points, but I think given the pressure of time, I have to do this. I start this by reminding the court about Lord Russell's use of the word rivals in Southern Railway. And you'll remember my submissions about that. He was simply using that word to describe the fact that there are two potential occupiers of the site. He wasn't suggesting that it was relevant to know whether the two candidates were in business rivalry. And when he applied his purpose test, what he did, and all that was ever done in Southern Railway, was ask what rights did the Smiths and so on occupiers acquire under the transaction which took place? What rights did they acquire under the licence? He never asked why was the transaction entered into. He never approached the question of purpose in that way. He didn't ask the why question. That's the background. And I can now trace how the problem has crept into the law. If we go to Clydesdale, first of all at page 1825, the foot of the page, we're now in the argument for the ratepayer.
This is the argument before the Lands Tribunal.
Lands Tribunal, yes. He said, dicta about rival use and predominant purpose were in his submission irrelevant. Here, use of the site for the supply of money was one use benefiting both parties. He was saying that in a case where there is no business rivalry, you can forget about the strict Southern Railway approach. The valuation officer didn't answer that point. I wonder whether its significance was noticed. But it's the point that the tribunal picks up on, and we can trace this through at 1830. In the paragraph beginning, it's not disputed. It's not disputed that the effect of the dicta, the dicta, as they're put, in the Westminster Council and Old Consort cases, is to require any issue of rival occupancy of a hereditament or unit of lands and heritages to be determined solely by reference to the premises as carved out. So there's recognition that that is the, so to speak, the conventional approach. But then at page 1833, we see the use it starts to make, this idea of rivalry. The foot of the page, to give proper weight to the interrelationship of the elements of analysis, we think it necessary to consider the nature of the subjects and the arrangements for their use in light of the nature of the shops and stores and the role of ATMs in them. A fundamental characteristic of each of the subjects is that it is part of shop premises. The use made of it is part of the premises of the shop. It's not disputed that if the cash machines were owned and operated by the storekeeper, they would be viewed as a routine part of his trading operation. We consider that before they could be treated as having been carved out of the shop so as to be in the rateable occupation of the bank, it would be necessary to identify some rival occupation by the bank which in a realistic way could be said to interfere with the use of the whole premises for the shop or storekeeper's purposes. In other words, unless there is business rivalry, not only do you not apply the conventional Southern Railway approach, you turn it on its head. You ask whether the sub-occupier interferes with the host. That is a very bold reversal for the Lands Tribunal to have made, with all due respect. And we see what it thought it was doing very clearly at the foot of page 1834. Where a supposed hereditament can be said to be occupied by two potential occupants at the same time, the question of rateable occupancy depends upon the question of whose possession is paramount, and that is to be considered in regard to the purpose of occupation. The fourth principle in Old Consort appears to elaborate that by reference to the test of control. Of course, that's not an elaboration. That is root, that is key to the Southern Railway approach. Nevertheless, the tribunal says, but it's not always clear that this test can provide an answer where the supposed occupiers are not truly rivals, but both deriving a direct benefit from the same use of the subjects. We think that the question of control must be seen as essentially subordinate to the broad question of purpose. So the court sees that in order to unlock an unconventional approach to purpose, one which looks instead of what is going on each unit, but why is it going on? In order to unlock that broad approach to purpose, the tribunal depends on this idea of rivalry, an idea which is profoundly misconceived, as profoundly misconceived as it is possible to be. It is just not a sustainable reading of anything said by any judge in any case, including Lord Russell in Southern Railway. And we can trace the consequences. In our case, if we go to the Upper Tribunal's decision, in paragraph 167.
So we're not looking at the higher Lord Gill.
My Lord, we certainly can, but
No, I'm not saying we should. I mean,
this is the reason that particularly Mr. Kalinsky fastens on.
Yes.
In the Bank of Ireland, I think one of the judges says that in the Lands Valuation Appeal Court in Scotland, they essentially approved what had been said.
Yes, I think that may be the answer, in which case we don't need
I will come back to what the appeal court said in Clydesdale. They are quite short judgments.
I mean, as I understand what the tribunal are doing here, they're distinguishing Westminster Council on the footing. The explanation, the reasoning really begins at the foot of 1829, where, having set out the assessor's argument, they say, we accept counsel for the ratepayer's criticism, essentially on the basis that the supposed existence of a heritable unit, in other words, a hereditament, is not a sound starting point when that unit can only be identified by examination of contractual arrangements for its use.
Yes.
So they're really saying that before you get to the question of who is in occupation, you have to decide, first of all, is there a hereditament? And it's in relation to that question that they're looking at issues of functionality.
My Lord, your Lordship may be right, but when I said I was skipping over the detail to save time, I'm genuine about that.
Yeah, also, well,
Because
I'm
you
also,
appreciate I'm critical of that. That is one of the many passages in this judgment of which I am critical. What I've tried to do is isolate how the thinking went wrong, because the roadmap I've just shown you seems to be the key that unlocks in the mind of the tribunal the opportunity to approach the question of purpose otherwise than through the prism of control. It seems to be that which unlocked in the mind of the tribunal that it was free to reject the step-by-step approach which is here recorded. I'm not saying that within the approach it has taken instead, there aren't many criticisms to be made. The reverse, at almost every sentence is open to criticism when you stack this up against Southern Railway in point of detail. What I've tried to do is give you a roadmap to how it went wrong. I was going to go to the upper tribunal's decision in our case, I hope briefly. Paragraph 167. This is memory stick 316. Well, this may be the point my Lord Reed had in mind, but here expressed by the tribunal, I'm not sure. But the tribunal said, far from distinguishing Southern Railway, from disregarding Southern Railway, the tribunal explained that in cases of concurrent occupation, the question of rateable occupancy depends on the question of whose possession is paramount, and that is to be considered in regard to the purpose of occupation. The tribunal's sole modification of the approach taken in Southern Railway concerned the value of control as a means of resolving the issue of paramount occupation. In this very different factual context, where occupiers are not truly rivals but are deriving a direct benefit from the same use of the subjects, it regarded the question of control as essentially subordinate to the broad question of purpose. That seems to us to be an unobjectionable refinement. Well, I object very strongly, and for reasons I hope are now clear. It's completely wrong, and it's the springboard for it is this unsustainable reading of rivalry. That is the gateway that opened in the mind of the tribunal in Clydesdale and in the mind of the upper tribunal the potential to examine purpose on a broad basis, as it put it, otherwise than by examining how the host's control interfered with the occupation of the occupier. Once that gateway is shut off, so too is the availability of this broad approach to purpose. That's why I'm so keen to emphasize how the problem arose. Following through in the upper tribunal's decision, we see this theme continuing in paragraph 170.
They've misunderstood, I think, what the tribunal was saying. The tribunal's decision was there was no separate hereditament, and that's why, at the end of the day, they decided there shouldn't be an entry on the roll.
My Lord, I respectfully agree with that. I think, actually, that is ultimately, if you want to put it this way, the ratio.
Yeah.
However, the way the Clydesdale tribunal got to that conclusion involves this error that I've identified. And it's this error which is now producing the problem. Paragraph 170, Lord Russell's explanation in Southern Railway that what matters is the position and rights of the parties in respect to the premises in question and the purpose of the occupation of those premises. it is applied by the tribunal to the external facing sites. That's what it calls I think it calls it somewhere the conventional approach. But at especially page 190, a different approach is taken to the internal ATMs. Because of the tribunal's view that it's entitled to examine the purpose for which land is used, otherwise than by asking the control question. Otherwise than by asking what is the bank doing, and is what it's doing interfered with by the host. Now, I appreciate that the upper tribunal has sought to distance itself from the question of rivalry, and it recognised that that wasn't always going to be a helpful thing to do. At paragraph 176 on memory stick 318, we don't consider that it's generally helpful to characterise the store and the bank as rivals in their occupation of the site of an ATM. And at the foot of that paragraph, at the top of page 319, even in the case of a small store, we regard the concept of rivalry in occupation as artificial and unhelpful when considering which party's occupation of the ATM of an ATM is rateable. But on the other hand, it goes on in 177 to say, when considering rateable occupation in the context of a complementary activity like the provision of an ATM, we don't regard control or interference as particularly relevant considerations either. So with all respect, it's a little bit difficult to know what to make of that reasoning. It's saying, on the one hand, rivalry is not relevant, but on the other hand, where you've got complementary activities, Southern Railway doesn't apply. It seems to be saying the same thing. It seems to be saying you only need to apply the control test where you find the activities are not complementary. And that a finding that the uses are complementary is enough to make control and interference not particularly relevant. It's a bit difficult to know what to make of that, with respect. And I say that genuinely. I defer to nobody in my respect for the Deputy President of the Upper Tribunal. But it's difficult to know quite what to make of that reason. And then in the Court of Appeal, at paragraph 86, there is, this is memory stick 274, an analysis which leads the court to say that the tribunal was wrong to have regarded the Scottish courts as applying a different approach from Southern Railway. The court says, I can't agree with the tribunal's conclusion that in the Scottish cases one can discern on the part of the court an intentional modification or refinement to the approach indicated in
So which paragraph?
167, 86, my lord, on page 274. Memory stick 274.
Yep.
And the Court of Appeal, this is a promising, it's a promising paragraph for me, because at the foot of the paragraph, the court says the absence of such interference or inconsistency doesn't have the effect of disapplying the principle of general control or call for it to be modified or refined by the introduction of a test of dominant or primary purpose such as the tribunal seems to have applied here. So far, one might think that's good. The valuation officers have succeeded in persuading the Court of Appeal that the upper tribunal was wrong. The problem is the Court of Appeal, although it's rejected the reasoning of the upper tribunal, has overlooked that the only justification for applying the general control test in a way which looks at joint purpose is if the door has been opened by the absence of rivalry. It overlooks that point in its reasoning. And so the Court of Appeal falls into the trap of applying the general control test in the same way as the upper tribunal, even though it has rejected the upper tribunal's explicit reasons for thinking that a broad approach to purpose was available. Now, I realise I've taken that in a very compressed way, and again, I'm not discouraging the court from reading or inviting questions about any part of this judgment, but that, it seems to me, if you want to track through how this problem has arisen, is probably as good a way of doing it as any. In a nutshell, although the courts have now put distance between themselves and this idea, this misinterpretation that seems to have happened about Lord Russell's use of the word rivalry, the dissociation is in point of form only. The substance of the problems which flow from that has not been expunged. Returning to Clydesdale at memory stick 1836, I was then going to go to the...
Yes, the passage you took us to in tribunal judgment, I think, must be obiter, because it's proceeding explicitly on the assumption of a separate hereditament. They then say this hypothetical hereditament remains in the paramount occupancy of the shop rather than the bank. But that's but their actual decision is to reject the hypothesis of a separate hereditament.
My Lord, I think that might be right if one is analysing this from the perspective of which parts are ratio and which parts are obiter. I think I would be inclined to accept that. My reason for taking you to that passage, as I hope I've made clear, was not to do that kind of legal analysis. It was to show you how the problem seems to have arisen and why it is that the tribunal seems to have thought it was open to it to depart from Southern Railway, even though, or let me put it this way, whether or not that formed part of the ratio. I'm not sure I should so quickly move away from that, actually. I think I'm going to submit that when one looks at the bottom of page 1834, one is finding an explanation which is part of the ratio, a justification for what the tribunal recognises it has done.
1834 at the bottom.
1834 at the bottom, towards 1835 at the top. I may have been too quick to say, yes, it's just over. I'm not sure actually it is. It seems to be part of the justification, albeit out of place within the writing of the judgment, for what the tribunal is conscious it's done.
This whole chapter just doesn't surface in the judgments in the Lands Valuation Appeal Court.
That is true. I agree, that is true. But you can see its effect in the upper tribunal in our case, as I've shown you, and the Court of Appeal found it necessary to deal with it. But as my Lord points out in the judgment of Lord Justice Clerk Gill, when the matter went on appeal, at page 1841, 1842, the decision seems to have gone on the basis that the ATM was movable. There's an acceptance that a chattel and occupation of a chattel can be a hereditament. But it was said at paragraph 27 that wasn't the case here. And the flaw in these appeals, said Lord Gill, lies in the contention that the agreements confer a right of occupation of the floor space on the bank. In my opinion, neither agreement has that effect. Both agreements relate to the supply, use and control of an item of movable property that the bank supplies to the retailer, whether or not the bank looks after it on a day-to-day basis for use by the retailer as one of its retail operations. With respect, that is not, that's not consistent with the contractual position.
Movable property is that's simply the Scottish equivalent of chattel.
Chattel, as I understand it, yes. And again, we find here, unfortunately, not the analysis of the contractual provisions and a comparison of them with the contracts in Southern Railway that would have shed light on this. It's dealt with at far too impressionistic a level. There is nothing about the agreements considered in Clydesdale that could not equally have been said about the agreements in Southern Railway. If there is, Lord Gill doesn't tell us what it is. Lord Kingarth didn't give a substantive judgment. Lord Clark did, but if I may say so, his judgment seems to be very strongly influenced by the old heresy that we need possession. At the bottom of page 1842. And that's what lets him analyse the rights granted by the licence as if he were explaining that you can't be rateable in respect of an easement. He's forgetting that you can occupy through chattels. He's forgetting that the rights he's describing over at page 1843 are exactly the same, mutatis mutandis, as the rights of the occupiers of kiosks and showcases in Southern Railway. And there's no grappling either. If you look at the end of this part of the judgment, there's no grappling with the similarity between the observations here made and the facts in Wilkins, the huts. Also movable. Doesn't matter. Doesn't matter who chose where they should go. Doesn't matter that they might be moved at a moment's notice. None of it's relevant. And none of that is grappled with at all. Literally not grappled with at all. The next case is the Bank of Ireland case. This is in tab 6 of volume 1, memory stick 1016. My submission about this case is that except for the way in which it seeks to distinguish Clydesdale, this is very much an orthodox application of Southern Railway principles. The difference is that the facts here were that the ATM faced outwards. And applying what I say is pretty much a conventional Southern Railway approach, the Bank of Ireland rightly concluded that they should be rated. The problem is that its reasoning is affected by the desire to distinguish Clydesdale rather than simply saying Clydesdale is wrong.
That's not very surprising.
No.
You know, in a sense, once you've got Clydesdale, then it's not surprising that tribunals follow that approach.
My Lord, that may well be right. And it may be me reading too many subtexts. I'm not sure I detect in the judgments in the Bank of Ireland case much enthusiasm for Clydesdale. I might be wrong about
Well,
that.
I mean, that doesn't really matter, does it?
But anyway.
No, we're not bound by it. And
No.
it's nice to find a case which you say is right. That's one you say is right.
It's right, but not necessarily for the right not fully for the right reasons. But I accept that the result is right. So hopefully what I've now shown you from the cases is sufficient to make clear why I have advanced in my printed case the criticisms that I have made in the printed case of the decision of the Court of Appeal in our case, and where the upper tribunal was against me of its decision in our case also. On particular points, movability, I believe I've shown you the passages from Southern Railway where Lord Wright explicitly points out that movability isn't relevant, it's transience. And all the law lords in Wilkins were making the same point. The question is never, could it be moved, but always, is it moved? On the question of how you identify hereditament, and whether it matters that apart from the occupation there wouldn't be a separate hereditament. Again, we've covered the ground. By reference in particular, if you want a hook for this, to my example of the mechanic's yard. Mr. Kalinsky refers on this point to the case of Vitesse. This is in tab 20 of volume 1. Memory stick 1263. Vitesse is the case which held that the optical fibres that were leased by Vitesse from the person who owned them were in the rateable occupation of Vitesse, even though it didn't own them. Its occupation of each fibre was manifested by the lighting of the fibre. That was enough to constitute rateable occupation. That is the level of granularity at which rating principle falls to be applied. I commend the reasoning of the Lands Tribunal in that case, which is approved ultimately by the Court of Appeal, the relevant bits being set out at 1274 to 1275. I can't read it out at length. I invite people to consider what the then President of the Tribunal said as they're quoted, particularly inner paragraph 38, and I say inner because it's a subset of Lord Justice Lloyd's paragraph 13.
Are we told who was the then Chairman?
It was Mr. Bartlett, George
It was
Bartlett.
Mr. Bartlett, yeah. Didn't say.
And at 42, this is just halfway down, page 1275, I don't think that the robust common sense approach urged by counsel for Vitesse, that these fibres physically form part of the cables and are really too small to be sensibly treated separately from the cables, is one by which the right result is reached. It may be, as I've said, that it's a sensible starting point to consider the ducts and cables as potential hereditaments or components of hereditaments, but the inquiry doesn't stop there, and if the fact shows they do here, that separate occupations have been carved out of component elements of the cables, those elements, no matter how small in diameter, are properly to be treated as part of the hereditament with which they're occupied. And in paragraph 15, you see the argument the Vitesse sought to advance in the Court of Appeal. The appellant's case is the extent of the hereditament must be determined without regard to occupation, or at least on the basis that the factor of occupation is not decisive, because occupation is a secondary issue and ought not to be addressed until one knows what is the hereditament in question. So there's an echo of that argument, I think, being pursued by Mr. Kalinsky, at least. Rejected, of course, by all the courts below, but nevertheless pursued. Lord Justice Lloyd, analysing the position, returned to that matter at paragraph 29, page 1282. More fundamentally, counsel for the appellant took issue with the proposition put forward in Wright that the concept of the hereditament for rating purposes is inextricably bound up with the concept of rateable occupation. He said that it was certainly closely connected with the question of occupation, which might in some cases be decisive, but that it was logically a distinct question prior to that of occupation. And Lord Justice Lloyd said it's not necessary to decide whether that's correct or not. And so there isn't here a decision on that point, because he gave the judgment with which Lord Justice Mummery agreed. Lord Justice Sedley did, in his, I don't know whether to call it a minority judgment or not, he didn't disagree, but he offered some independent reasons. And Mr. Kalinsky relies on these at paragraph 39 and 40, memory stick 1284 to 1285. Lord Justice Sedley said counsel for the appellant is right to segregate the two things and to insist that until a hereditament is identified, occupation cannot arise, if for no other reason than that what amounts to occupation will ordinarily depend on the physical and legal character of the hereditament. Well, for reasons I've been exploring through cases like Wilkins, I'm not sure I could agree with that proposition. And as it's obiter, I'm not sure it's in the sense that it's not part of the reasoning of the majority. I'm not sure it's productive to dwell on it. There's also reference by Lord Justice Sedley to the lodger principle, which he says is a recognised anomaly. But I don't place any particular weight on that any more than I do on, for reasons I've already given. It's not really a useful part of the decision. But I thought, in fairness, I ought to show you that. All judges looking at this have rejected the Cardtronics idea that there's no hereditament simply because the only way you can identify it is to look at what's occupied, and they were right to reject that idea. It's clearly wrong. On the plant and machineries point that Mr. Kalinsky takes, a related point, he says, well, this is just a chattel. And we've seen in my submission that doesn't matter, just doesn't matter. Plant and machinery regulations are concerned with valuation. You don't have to disregard a chattel where the question is not how much is the land worth, but does the occupation of the land disclose a separate hereditament? May I take a moment? I mean, my notes go on for several pages, but I'm wondering if I can...
Don't feel tempted.
I am tempted, of course.
Resist.
All right. Well, I'm sorry that means I end rather abruptly and without a peroration, but I think given the clock, it's better that I do that rather than try to wrap it up nicely for you.
Well, thank you very much, Mr. Morshead. Ms. Ward, do you follow? I think we are going to hear from Mr. Drabble next.
Well, what's the order of play? Sorry.
The order of play is followed by Mr. Mould for Tesco's, who has a point, an interest which largely overlaps, and we have discussed our respective roles in relation to that, which is the first and the main issue of common purpose. He has a separate issue on the movable ATMs in Tesco's. And then we have Mr. Kalinsky taking what we all three of us accept is actually logically the prior point of whether there is a separate identifiable hereditament. But if it's acceptable to the court, we'll do it in that order.
Fine. Provided we don't have repetition, we're content to hear it in whatever order you please.
We'll do our best to avoid that. Oh, and the same as, sorry, Mr. Roll also appears for co-op, but that fits into the into the general perspective. And we'll make his submissions for the co-op at the same time or immediately after the submissions for Tesco's. Yeah. Now, I wish to just try to give a fairly quick overview in the time that remains to me of the shape of our submissions, which are essentially those that were recorded by the Court of Appeal and accepted by the Court of Appeal. But I can just do it in my own way now. If I could ask the Court to pick up our case at MS 198. we have a heading called preliminary observations, but it does effectively function as an agenda for what I wish to say now. And one of the important thrusts of the submissions I make now is that the starting place, from our perspective, is that we are talking about what I might describe as a carve-out situation. We are starting from the position that there is a superstore, that the proposal that is put forward by the valuation officer is to break out of the superstore a smaller unit, namely the site of the ATM. We submit, and I'll try and make this good possibly today, by reference to the dicta of Lord Herschel in Hawking, that exercise necessarily involves, has always been recognised to involve, looking both at what was happening in the larger unit, the overall unbroken store, which is functioning as a shop with lots of attractions, and what is going to happen, or does happen, within the smaller unit. The idea that you can focus simply on what happens in the smaller unit in a carve-out situation is obviously only half the truth. You have to look at the purposes of both the occupier of the larger unit and of the smaller unit to see whether the criteria for treating the smaller unit as a separate hereditament are fulfilled. That's the issue.
Well, you'll come to it, no doubt, but are you going to be saying that the Southern Railway was not a carve-out case?
No, I'm not going to be saying that, but it on the, sorry, I've been told my mics are not pointing quite right. No, I'm not, obviously the Southern Railway is a carve-out case, but it's one in which the characteristics of the units carved out have a very clear and distinctly separate purpose behind the occupation of the bookstore, let's just stay with the bookshop, from the running of the station. And we'll see that theme picked up when we come to the ATM cases in Stringer. But that perspective informs very much what's happening in Southern Railway. Now, in our case, if we look at the observations we make, first of all, in paragraph 4.1 of the printed case, we say that the ATM sites at Worcester and Stroud are within a unit of property that would be readily recognisable to the observer as a supermarket. The fact is reflected in the original description of the hereditament before the valuation officer's alterations, which carved out separate hereditaments for the sites of the ATMs. It's common for operators of hereditaments to provide within the store a range of facilities such as photo booths, coin change machines, and relevant ATMs. Then we go on to say that the store's evidence, SSL's evidence, was to the effect that it expected to see ATMs provided as a matter of routine at each supermarket. We'll come back to that.
Yeah.
But we are dealing not with a station, but with a store which provides a number of retail attractions, some of which we've indicated there. There was some discussion this morning about whether the coin change machines, Coinstar I think it is actually, are separately rated. The answer is they haven't been until very recently. In the course of the progression of this litigation, proposals, I am instructed, proposals to produce a separate hereditament of the site of the Coinstar machines on the cases in the 5 or 6 cases that have gone on appeal. In other words, these cases have been inserted by the valuation officers into the list. That process has stopped, pending, no doubt, the results of this case. But the court should not be in any doubt that the result of accepting the submissions of the valuation officer, that one applies Southern Railways to the circumstances of a superstore in the way in which Mr. Morshead invites you to do would be to lead to what he describes as a process of atomization. You would have at least an argument for a whole range of separate hereditaments within the confines of the superstore. Now, we say that fragmentation is not necessary and doesn't follow from the correct application of the principles to be applied when you're considering the characteristics of the store read together with the putative hereditament consisting of the smaller unit. So we go on in paragraph 4.2 to say that apparent from the facts set out above that the sites on which the ATMs are situated are currently jointly occupied by SSL and the bank. Now, Mr. Morshead, when asked, said that his case was that it was only the bank that was in occupation. One has to be careful about the process by which you get to that conclusion. It's a matter of property law, analysis of the contracts, however one wants to put it. There seems to be no doubt that there is joint occupation. That is, the store has retained occupancy rights over the concrete base on which the ATMs rest. There's a finding by the tribunal, the upper tribunal, in the present case referred to by the Court of Appeal. The finding is in paragraph 169 of the upper tribunal decision to the effect that the stores have not parted with possession of the sites in any of these cases and are in joint occupation with the banks in all of these cases. Mr. Morshead hasn't...
I beg your pardon, when you say all of these cases, you mean all of your cases?
Well, actually all of the cases. I mean, I meant all of the cases, although it may not be my part to say it in the other.
Thank you.
169 is in general terms.
Yeah.
And just to remind ourselves, Mr. Drabble, in Sainsbury's cases, we're talking about machines to which the public have access from the exterior of the building. Internally, the machine sits inside a secure room, which is also used for storing cash and so on by Sainsbury, the store operator.
Yes.
And the hereditament entered in the roll is the area of the floor space on which the machine sits. Is that
Yes. Yes. The facts on the Sainsbury's cases are effectively identical to the facts in Stringer, the case to which my learned friend took you half an hour ago or so. We're talking about the base of the ATMs in the secure room being used for dealing with the whole cash of the store, so that there's a safe in which the store puts the cash from the tills, which arrives through a vacuum pipe, actually. It comes with a great big whoosh. You sit in the storeroom, put in the safe, and obviously the store keeps separate the deliveries of cash which go into the ATMs. It's they're external facing in the Sainsbury's cases. But there is, as I say, the tribunal, upper tribunal, approached the matter on the basis that there was no parting with possession in both Sainsbury's and any of the other cases with the site of the ATM and joint occupation. And my learned friend hasn't submitted that's wrong, and I understand why, because his approach, understandably, is that as a matter of rating law, legal analysis of the rights of possession doesn't conclude the question. But, and this is the important but, if you're dealing with a carve-out position, you do have a situation in which on those facts, two candidates are arguably in occupation, and you have to decide which of them is the rateable occupier. You'll come out with an answer: there's only one rateable occupier. But you will do so by comparing the positions of two people with occupancy claims. You do so by applying the approach in the carve-out cases, which include the classic dicta of Lord Herschel in Holkin, which I'll come to in just a moment. So going back to 4.2 of our printed case, we're dealing with a position in which the sites of the ATMs are jointly occupied by SSL and the bank. SSL is not part of the possession of the sites and uses its position in relation to the sites to ensure they are used to provide a functioning ATM, one of the facilities which it routinely expects to see provided at stores such as these. And then our core submission, in other words, it's retained sufficient control over the ATM sites to ensure that the common purpose providing ATM services at the store can be delivered. And we go on to submit that given the fact that you're dealing with the question of whether or not the smaller unit has become a separate hereditament or ought to be treated as a separate hereditament, the approach of the Scottish courts is in fact correct, because it answers the question of whether the sites are occupied for different purposes, and that the approach in Stringer is also correct, with the caveat that it shouldn't be based upon Gilbert and Higginbottom. I'll come to that in due course.
You want to come to the point is why, I mean, it would obviously be said of the station that one routinely expects to find a Smith's bookstall there. And it's part of the facilities which are provided in the station. What's the difference?
Well, the difference is that well, let me go straight to Clydesdale. It's possibly that I can try and answer that crisply by reference to Clydesdale. And go to the additional authority. The much criticised passage by Mr. Morshead is at the foot of page 1834. Your Lordships and my lady will remember that Mr. Morshead alights on this passage as indicating that the court or the tribunal in Clydesdale took a wrong turning. Passages where a supposed hereditament can be said to be occupied by two potential occupants at the same time. The question of rateable occupancy depends upon the question of whose possession is paramount, and that is to be considered in regard to the purpose of occupation, the third principle set out in the old consort case. The fourth principle appears to elaborate that by reference to the test of control, but it's not always clear that this test can provide the answer where the supposed occupiers are not truly rivals, but where both were deriving a direct benefit from the same use of the subject. Now, that's the concept. I'll say probably tomorrow that we can approach the practical legal answer to the problem in this case, either by the concept of general control, which is what the Court of Appeal did, or by saying you look at purpose rather than control, which is what the tribunal does in Clydesdale.
I beg your pardon. Could you please just repeat that last sentence? Your voice dropped.
I say I will be submitting probably tomorrow that you can approach the problem thrown up by this case either by resorting to the concept of general control, which is what the Court of Appeal did in the present case, or to the looking at the common purpose getting the same answer from the common purpose, which is what Clydesdale did, subject to the caveat that it was principally concerned with the identification of a hereditament. I accept that. But the underlying difference, to answer my Lord Palmer's answer, is if you look at what's happening on the ATM side, is that both candidate occupiers are deriving a direct benefit from the same use of the subjects. That's the nature of the common venture, which is identified in Stringer. We say Stringer is correct because it...
Sorry, I mean, how does that differ from the bookstall in the Smith's bookstall in the station? I mean, the benefit is providing newspapers to the customers, which is for the customers of the railway as well as of the shop.
Well, no, it's
They're not rivals in any sense.
no, I
It's in
mean,
the interest of the railway to have a bookstall there because that's what its customers want. And it's the same direct benefit, isn't it?
Well, I wonder whether it's a benefit to the railway company to have. It's a facility which is provided for its customers, but it's not intrinsically likely to attract those who are going to use the railway.
Well, I wonder. I mean, you know, I'm very anxious because this seems to be at the heart of this case.
well, I mean, we've gone straight there.
I'm very keen either today or tomorrow to get your submission or the other respondent's submission as to how we get over, because that at the end of the day is what Mr. Morset has been banging on about.
Well,
with force, and he's entitled to, because it's a very good point.
I mean, the answer is the nature of a store. The store provides a range of facilities to function as a store and to attract its customers. The range of facilities consists of ATMs, coin stars, the food that's on display, the ice cream example my Lord Reed put in argument, the whole range of them. And the direct benefit is the promotion of the location as a retail attraction. Now, a station, I agree, you may think it's nice for passengers to have papers to read on the train. It plainly is, but it's not the direct benefit from the same use of the bookstall itself.
You're unlikely to take a train journey just for the joy of going into W.H. Smith.
Yeah.
No.
I'm not sure I'm likely to go to a supermarket just for the joy of getting cash out of it. I think this is the trouble. You may be right, but it seems to be a potentially very subtle distinction. And this whole line of cases is going to turn on this point. We need to be very precise about what we're saying.
Yes, if I may say so, that point is rather highlighted by the Bank of Ireland case, where the court found that because the cash machine was on a high street, external, on the exterior of the building, it was attracting. It was something that would be used by passers-by, independently of their use of the shop, and obviously it was open 24 hours a day, unlike the post office it was in that case, and so it was distinguishable in terms of its beneficial use. And the same might be said of a Sainsbury mini store that's on the high street in Clapham or wherever it is. But if it's a Sainsbury's superstore that people go to in their cars, or it's located in the middle of an enormous car park, then it's more difficult to imagine a casual passerby going there to get cash out of a machine. The way Lord Markham addressed this in the Bank of Ireland case was by reference to Lord Keefe of Avonholme in a House of Lords case, Greenock and Arbuckle Smith and Co., that for rateable occupation there had to be such use as would amount to enjoyment of the beneficial value of the subject, which is perhaps a...
Yes, I think he goes on to talk about a uncontrolled use with a sufficient disconnection. I'm not getting the wording exactly right, but the phrases of that sort. Yeah. Sufficient disconnection from the use of the post office. Yeah. Whereas here, if you get hold of the fact that the store is providing a range of attractions, then there isn't a there is a direct link with the use of the store, in which the store is participating. By store, I mean shorthand for SSL, but SSL is participating in the provision of the services. And they're therefore, to go back to the phrase in Clydesdale, they're deriving a direct benefit from the same use of the subject. That fulfills Lord Malcolm's criteria in the judgment in Bank of Ireland. So the answer, I mean, that is the answer I'll give. I'll come back to that tomorrow morning. Can I just kind of round off this overview by taking the court to hulking? We haven't seen hulking. It's a very important part of our approach. You'll find hulking at tab 11. The facts of hulking were that you can see from the head note that the owner of the land, who was the Duke of Westminster, I think. Yes, it was the Duke of Westminster, had granted or been required by statute to grant certain rights to the Hulking District Mines Drainage Company to locate a tunnel. And the issue was whether that was a separate hereditament. And the approach to whether it was a separate hereditament was set out by Lord Herschel at page 126 of the report. That's MS 1125. Strongly contended on behalf of the respondents, just under halfway down the page, strongly contended on behalf of the respondents that they should not be liable to be rated in as much as they were not in exclusive occupation. There are many cases where two persons may, without impropriety, be said to occupy the same land, and the question has sometimes arisen which of them is rateable. Where a person already in possession has given to another possession of part of his premises, if that possession be not exclusive, it does not cease to be liable to the rate, nor does the other become so. A familiar illustration of this occurs in the case of a landlord and his lodger. Both are, in a sense, in occupation, but the occupation of the landlord is paramount, that of the lodger subordinate. So the concept I want for this evening is that start with a person already in possession of the premises. That's the store. You ask whether that possession is not exclusive. The answer is, well, as a matter of land law, on paragraph 169, we know the answer to that is no. Move behind the concept of possession in that strict property sense to the rating concept of do they occupy for the same purpose. The answer on the approach taken by the Court of Appeal and indeed would have been taken by the tribunal in Clydesdale is the answer is yes, they do occupy for the same purpose. Therefore, the possession is not the possession of the bank is not exclusive. And on that basis, there is no carve out of the smaller unit. The store remains a single hereditament, unbroken by a separate hereditament in the hands of the bank. Now, that doesn't mean the bank doesn't have sufficient rights to operate as a bank or to carry out the ATM services. It simply means that it's doing that in parallel with a situation in which the store still has occupancy rights over the ATM site, which it is using to facilitate the provision of cash to its customers. And for that reason, we say the criteria in Harkin are not, for a separate hereditament, are not satisfied, and there's been no carve-out. That's the starting point. That's the way round we say you have to approach the issue.
Could I just, pausing there, could I just flag up an issue I did put to Mr. Moore's head, which is probably irrelevant, but this question of valuation, how on given a bit of floor space which has on it an ATM machine, and you have to disregard the ATM machine for valuation purposes, how does it come that it has a substantial value over which you're all prepared to fight to this extent? How does one get to a value of something which, by definition, can't be used for the one purpose which it's been identified for? It's got to be perhaps you can
come back to that. I mean, there's a related issue about that, which goes to my learned friend Mr. Morsett's fairness point.
Yes.
But I mean, the actual position in terms of what's happening.
Well, don't worry now. I just
I
want to
won't
make
worry
sure that someone covers that tomorrow.
Yeah.
So is that a convenient point?
If that's a convenient moment, yes.
Very well then, we'll adjourn for the day.
Till 11.
Yes, until 11.
Till 11, indeed.